Let me start with the last session today. We are going to talk about gender perspective of private law and public policies. So we have quite a number of speakers. So in advance, I would like them to ask to keep their presentation in 10 minutes time. I have a pleasure first to announce as a first speaker Professor Rosemary Hunter. She already spoke yesterday, but this time she's going to talk about reproduction of gender differences in heteronormativity in family law. So, Professor.
Right, thank you very much. Yes, so if we can have the PowerPoint.
Yes, let me just share. Okay.
We need to open it first.
Yeah, it's open.
Oh, okay.
It's here.
Aha, yeah, that's it.
So I should close the others, I guess. Quite a number. This.
Mm-hmm.
Okay.
And then can we make it into the full
presentation?
presentation? Great. All right. Thank you very much. And thank you. I'm now talking about the chapter that I've written for the collection of essays, and I'll do so very quickly. And I know that we'd be hearing from others about family law as well. But the chapter that I wrote was sort of concentrated on the ways in which family law continually reproduces gender difference and heteronormativity. And I think it's important to say something about how I see the relationship between those two things, which is not that one is more important than the other, but that they're absolutely intertwined with each other, and that heteronormativity and gender difference are two sides of the same coin, that gender difference is mostly about sort of the individual, whereas heteronormativity is about the nature of relationships and family relationships. So, it's not going to move. Thank you. Right. Which one did you press?
Oh, this one.
That one, yeah. Okay. Right. So, it's certainly true that family law, perhaps more than any other area, is an absolutely key site for the transmission of gender norms with regard to and heteronormativity with regard to adult relationships and the parenting of children and expectations around the construction of families and family relationships. And obviously, specific legal rules vary between different jurisdictions, but very similar questions arise. And of course, the other point I think that's probably important to observe is that law, of course, responds to changing social practices and to medical and technological and economic developments. But my argument in the chapter is not that gender and heteronormativity are likely to be transcended, but rather that they are reproduced and reconfigured in different forms according to the ways in which society, technology, economics develops. And I'm just going to talk about sort of a few broad areas where we see these patterns. So first of all, in relation to legally recognised relationships, I think it's fairly well accepted that heterosexual marriage is both the social and the legal norm for adult relationships, although the nature of our conception of heterosexual marriage might have changed from being one in which gender roles within marriage were very strongly distinguished to perhaps being one in which marriage is conceived of as a partnership of equals, although precisely what that means and the extent to which that shift has occurred, I think it varies quite considerably. But the idea of heterosexual marriage as the norm then raises questions about, for example, the recognition of cohabiting relationships. Are they recognised in the same way as marriage relationships, or are they not legally recognised? And certainly in the UK, for example, cohabiting relationships have no legal status at all. And so people who are in cohabiting relationships don't have access to the same kinds of rights and remedies that married couples do. Also questions, obviously, about the recognition of same-sex relationships, and if they are legally recognised, is that through access to the sort of gold standard of marriage, or is it through the creation of some other status, such as a civil partnership or a registered partnership? And then, we've seen debates in different areas about, well, what will be the effect of recognising same-sex relationships on heterosexual marriage? So we have conservatives who are very concerned that the recognition of same-sex relationships will devalue heterosexual marriage. And on the other hand, we've had some of the sort of queer arguments, which are about the potential for same-sex recognition of same-sex relationships to radically transform the notion of marriage. And I think we're probably somewhere in between, but those are questions that continue to bubble away in this context. But a sort of more fundamental question, and a question that very few jurisdictions have tackled, is one about the recognition of non-conjugal relationships, so mutually caring dependent relationships that aren't based on a sexual relationship. So things like close friends or people who share their lives or their finances for a variety of different reasons. And there are some arguments about the need to provide legal recognition and legal protection for those kind of relationships, but very few countries have taken that forward. There are a few examples in the world, but not very many. Okay, so then in relation to the attribution of legal parenthood, this is another area where the gender binary or gender difference we see being sort of quite consistently reproduced. So first of all, the question, obviously law recognises and knows what to do when children are conceived naturally through a heterosexual relationship. Certainly within marriage, question about what it does when children come out of a heterosexual relationship outside marriage. But the attribution of parenthood is very much about gender difference. So you would have a father and a mother being attributed rather than any kind of sort of gender neutral parenting. Obviously, when we get to assisted reproductive technologies, it's not obvious necessarily who would be counted as the parents. There might be a number of different progenitors, gamete donors, the woman who gives birth, the intending parents, and so on. So the law has to make some decisions about the attribution of parenthood in that context. So there's questions about things like who has access to reproductive technologies. Is it confined to heterosexual married couples, or is it extended more broadly? Again, the law tends to reproduce in this context the ascription of motherhood and fatherhood rather than any sort of more broad notion of parenthood. And there's also, in most places, to the extent that it is recognised and accessible, there is still an insistence that a child can only have two legal parents rather than it's a sort of legal recognition of so-called polyparenting relationships. So if you have a lesbian couple and a gay male couple who decide to have a child together, they all contribute to the production of that child in some way, but they can't all be recognised as legal parents of that child. And the other issue, an issue that's come up particularly in the UK, around trans men giving birth to children. And we had a case recently, this is a picture of a chap called Freddie McConnell who is a trans man, but who gave birth to a child, and he wanted to be legally recognised as the father of the child because that's his gender identity. But the court decided that since he was the definition of a mother is the woman who gives birth to the child, and since he had given birth to the child, he could only be registered as the mother of the child rather than the father of the child. And that is simply a matter of judicial choice, because it was very clear that you could have said, well, okay, the woman who gives birth to a child is the mother, but he's not a woman who gave birth to a child, therefore, we have to find some sui generis way of dealing with this. But the court was absolutely stuck on the notion that giving birth equals motherhood. So that was a very interesting example of the sort of reproduction of gender difference in the parenting context. Division of marital property on divorce. Obviously, we're very well aware, and we talked in the last session about the gender division of labour in intact families, which then ends up as, or translates into, gendered advantage and disadvantage if that gender difference is ignored when it comes to divorce. And this is, again, something we've talked several times about over the last day or so. The issue about formal equality versus substantive equality. So if you simply divide property equally, then that doesn't account for the unequal needs and capacities of the different parties after divorce. If you only value financial contributions in distributing property, then that is going to be to the disadvantage of the homemaker. But if you say, right, it's all split equally, that is also to the disadvantage of the person who doesn't have the same level of earning capacity and is working in a labour market in which there is gender pay inequality. And so what we see as a consequence of that consistently throughout the world is the impoverishment of women and children following divorce, with men generally being better off financially after divorce and women being worse off. But unfortunately, the sort of direction of travel legally is towards a formal equality position rather than thinking about the different needs and the different positions and a more substantive equality approach to post-divorce property division. And then the final area that I want to talk about is in relation to post-separation parenting. And here too, there's been a bit of a direction of legal travel in the direction of equality, of sort of recognising both parents as equal in relation to their children, which it ignores the unequal contributions that have been made to childcare, usually during the relationship, and also ignores the fact that the practical burden of shared care tends to fall on mothers, and on children to make it work and to make it happen, to be the ones who adjust themselves and adjust their arrangements in order to enable the father to have equal time with his children. But at the same time, we continue to see different social and legal normative expectations in relation to the role of mothers and the role of fathers. So fathers are still tend to be seen as the person who provides the financial support, whereas the mother is the one who provides all the sacrifice, who gives up everything, who gives up her own interests, who gives up her own aspirations and career, etc., in the interests of her children. And mothers who don't do that, and mothers who don't then promote contact with the father, are punished and blamed. So a father is praised and rewarded for wanting to have contact with the child, but the mother is the one who has to make that happen, and if she doesn't, then she is blamed. And that also, in particular, leads to enormous difficulties for survivors of domestic abuse and their children for actually securing safety and protection through family law, when there's this sort of overwhelming emphasis on maintaining children maintaining relationships with both parents, even if one of those parents has been abusive or is dangerous to the other parent of the child. And then there's also questions, and the law hasn't necessarily worked out how to deal well with separations of gay and lesbian parents. And we've seen cases where there's kind of been almost a reproduction, an attempt to reconstitute the gay or lesbian family as a heterosexual family in order to try to work out, who should be responsible for what, rather than understanding perhaps the different arrangements in gay and lesbian relationships in relation to their children And also the law has continued to have difficulty with the concept of transgender parents, and how they should be slotted into this normative system. So the sort of very strong norm in favour of children maintaining contact with both of those parents seems to go out the window when one of those parents is transgender. And so we've had some cases where, well, at least one sort of quite high profile case where a transgender parent who wanted to have contact with their children was initially denied contact, in the same way that in an earlier age, gay and lesbian parents were denied contact because it was concerned about, what the damaging effect they might have to their children. Now, in that case, ultimately, the appeal court decided that they should be treated in exactly the same way as any other parent. But there is still a sense in which the law knows exactly what it's doing when it sees a heterosexual couple, but can lose its bearings when somebody different from, or when a couple different from that norm appears before it. So, my conclusion in the chapter is about the way, just to observe again that family laws are really thickly imbued with social and cultural norms and also with religious norms. And I haven't obviously in this very brief presentation talked about some of the ways in which religious personal laws impact on this. But again, they tend to reinforce the heterosexual married norm. And it's also an area which even though there are, human rights standards are articulated, rights to privacy, the right to marry and found a family, equal rights within marriage, and on dissolution, those human rights standards are very open-textured, they're indeterminate, and are themselves heteronormative. So the right to marry and found a family is a heteronormative standard and tends to be applied only to, that just means heterosexual marriage. Family, and so again, to repeat my earlier point, family laws continue to attach meanings to gender, to result in material advantages and disadvantages, continue to privilege some forms of relationships and marginalise others. So although we might see change over time, that doesn't necessarily equate to progress. Increasing gender neutrality can result in increasing disadvantages. And if we see, increasing lesbian and gay male inclusion, we also need to think about who remains excluded, the polyparenting projects, the non-conjugal relationships and so on. So that's just a very brief gallop through my chapter, and I'm looking forward to hearing the rest of the discussion. Thank you.
Thank you. I would like to thank Professor Hunter for this really interesting presentation, and I would like now give a word to a co-moderator of this session.
Do we need to swap again?
Yes,
Yes,
you
I
have
think
the
so.
session.
I think it's better.
Professor Rabadan from the University of Cadiz, and she's going to deliver a presentation on gender-competent family law. So we are still within the same field of law. Fuensanta, please.
Yes. Good afternoon. Okay, after the greatest intervention of Rosemary, I'm going to explain some issues about gender-competent family law. First of all, I would like to thank Professor Dragica Vujadinovic to invite me to University of Belgrade to let me participate in this conference and to let me participate in this great experience. It's a great experience in an academic aspect and in a personal aspect too. So thank you very much. And well, as I have said, I'm going to speak about my contribution, or our contribution, because I haven't written the chapter alone. I have written the chapter with many other colleagues. So our contribution to the textbook Gender Competent Legal Knowledge, and the topic of our chapter is Gender Competent Family Law. And this chapter has been written by by professor from University of Cádiz, Professor Amalia Blandino, Professor Letizia Coppo, and Gabriele Carapezza from Lunsa University, Professor Novakovic and Professor Barak from University of Belgrade, and Professor Sara Seidman for University of Örebro. So I'm just the representation, or they're just an aspect of all this person that have written this important chapter, who is that is gender competent family law. And in particular, I'm going to talk about my contribution, or one to my contribution in this chapter, because in this chapter we have a study from a gender perspective: marriage, divorce, unmarried couples, parenthood, affiliation rates, domestic violence. And one of my contribution is about the topic that I bring all of you today, that is parental responsibility, child custody, and child support. All of us know that over the century there has been a patriarchal family model. We know that the father has the power and has exercised his power over his children, his wife, his property, and the hegemonic position that man has in the public sphere is the same hegemonic position that the father has in the family. And the women, or the mother, remain in the private sphere, and the father is the breadwinner, and the mother is the person who is responsible for the care of the children. This patriarchal family has given way to an egalitarian family model. Nowadays, the European civil codes, for example, the Spanish civil code, establish that the mothers and father has the same duties, responsibility, and rights over their children. And this principle of co-responsibility has been also recognized in international legal texts. For instance, in the Convention of Elimination of Discrimination Against Women, the CEDAW, Article 5 and 16, or in the Convention on the Right of the Child, Article 18. I want to highlight that the inclusion of the principle of co-responsibility in the Convention on the Right of the Children can let us make a connection between the principle of co-responsibility and the best child's interest and the child's welfare. But we have to take into account that the co-responsibility has to be exercised according to the best minor interest. So the best minor interest has to lead the co-responsibility. And however, despite the legal recognition of equality, gender roles and stereotypes persist in family. Mothers are the main carers of children in practice, and that happened because the women has came into the public sphere, but the men has came into the private sphere in a comparative way with the women, inequally and completely lately. So for that reason, we can detect stereotypes in family in practice. As some voices have said, the current family presents elements or characteristics of an egalitarian family model and aspects of characteristic of a patriarchal family model. We can find a family model that has both sides. For that reason, positive and inclusive actions are required to remove these stereotypes in practice. And this action not has to be just focusing on women or in one area. This action have to involve different areas, law, education, economy, in a connected way to remove all these stereotypes in practice. On the other hand, inequality about parental responsibility has been so evident in cases of parents' divorce or breakup. For instance, the evolution of custody. Initially, custody was granted to the father because the father has the power and the mother lost their rights over the children after the divorce. In a second period, the custody was granted to the mother, according to the idea or under the idea that women are more capable to take care of the children than men. It's the doctrine of the tender years. And in this model of custody, the men pay the alimony. So the man, the breadwinner, the mother is the carer of the children. Public sphere, private sphere, or more or less this dichotomy that I highlight before. But the disadvantage of this system of custody is that the mother, in practice, has to support a significant burden in the children's care and education. And the father can have a fluid relationship with their children and can take part or important decision about children's health and education. And in this situation, in this context, the debate about shared custody arise. Shared custody is an egalitarian model that favors co-responsibility after the parents' divorce or breakup. However, there are some voices that have criticized shared custody. They consider that shared custody can't resolve or can't eliminate the inequalities between mothers and fathers if the father hasn't been involved in the caring of the children before the breakup. Moreover, they consider that shared custody is a patriarchal demand, that what really wants the fathers is to have the powers in the family, and what really wants the father is to get rid of their economic burdens. Despite these opinions, I think that it's true that shared custody is an egalitarian model, or is a model of co-responsibility after the parents' divorce or breakup. And this is in accordance with the international test that I have mentioned before. But in any case, the election of child custody and shared custody or other co-responsibility model, because shared custody is not the only model to reach to co-responsibility after the breakup. So there are other models, or even the election of a sole custody model has to be done according to the best minor interest. The Convention on the Rights of the Children says or established that best minor interest shall be a primary consideration ahead the parents' interest. But the fact is, in the practice, this indeterminate concept of the best minor interest has been manipulated to perpetuate gender stereotype. Many judges' decisions are based on a stereotype. For example, not to grant custody to the mother who wants to develop their career because she's not a good mother, or not to grant custody to the father because she's not capable, fathers in general, not in a concrete situation. Fathers or men are not capable to take care of small children, or not to grant custody to one parent or to another parent because of their sexual orientation. This stereotype has been the justification on many judges' decisions about child custody. So the conclusion is that the best minor interest must not be manipulated to perpetuate these gender stereotypes, and the election about shared custody must be done taking into account the circumstances of the family and, of course, the circumstances and the interests of the children. And that is my exposition, and thank you very much for attention. I haven't controlled myself, so I don't know if I speak more than 10 minutes. So excuse me if I.
going to have questions about the family law. So probably both of you are going to speak a little bit later again. And now we are moving from the family law to the other areas of private law. And I would first like to ask Professor Carapezza Figlia to deliver his presentation, his talk about these other fields, law and contracts, and he's going to present this online. So I think that we have good connection. So, Professor, please, you may start.
Good evening. Thank you very much. So, first of all, thank you very much to Professor Dragica Vujadinović for this kind invitation, and above all for the excellent work of coordination of our research group, a research group that I think has produced excellent intellectual outputs, and this LAWGEM conference, I think it's one of them. First of all, I have to focus on the need to revisit private law rules of a social market economy from a particular perspective, the gender perspective, that requires a reimagining of the relationship between production, competition, and solidarity, reconciling two principles that in general we consider in opposition: freedom of contract and equality in access to the market. And from the standpoint of general contract theory, the phenomenon of contractual discrimination describes the impact of preconceptions rooted throughout society on market mechanisms and contractual dynamics. So the sensitivity of contractual parties to the personal characteristics of the counterparty, including, in particular, gender, may influence the exercise of private autonomy, the exercise of freedom of contract. And we can observe discriminatory effects on two levels. First of all, preventing members of the disadvantaged group from acquiring the goods or services exchanged, or second effect, imposing different or more onerous contractual terms on the members of the disadvantaged group. So under the former scenario, the members of the disadvantaged group are prevented from enjoying goods or services as a result of the refusal to contract or the refusal to perform. Instead, under the latter, the market transforms the prejudice into a surcharge which is added to the price of the goods or services. So in this case, the social position of the victim of discrimination translates into a further cost, which he or she is forced to pay in order to obtain the contractual benefit. Anti-discrimination rules apply to situations of cultural conflict, situations which are characterized by the capacity of risk factor as gender to distort a transactional relationship by generating an opposition between contractual parties that needs to be resolved by the legal order. For example, these cultural conflicts may include the refusal by an estate agent to deal with transsexual clients, or the articles of a housing cooperative that state that only heterosexual people are eligible for membership, or the charging of different prices to different clients depending upon their sexual orientation. In these cases, the discrimination results both in a violation of the counterparty's human dignity and his or her freedom to access commercial exchanges, as well as in a market failure. Through a reduction in transactions and interference with the machinery of price formation. So there is an undermining of collective economic well-being. From the perspective of the economic analysis of law, the market is able of abolishing irrational constraints on its own, including those resulting from discrimination. And in this way, the task of removing discrimination within contractual exchanges must be left not to the law, but to competition. Because the victim of discrimination, who is considered as a buyer, will easily find an operator willing to sell him or her the goods or services at the market price. However, it has been shown that the market, especially where it's fragmented, is not only unable to abolish discriminatory practices, but also internalizes prejudice, social prejudice as gender within a broader mechanism for calculating costs and benefits. So, exogenous intervention to combat discrimination is necessary. And this intervention manifests itself in the legal prohibition of discrimination, which outlaws the transformation of differences which are matter of fact into inequalities as value judgment. And the elaboration over the last 2 or 3 decades of a complex anti-discrimination legislation often imposed by European law results from a model for heterogeneous market regulation focused on contract law. In order to prevent markets from distortion by prejudice, it's necessary to purge the full scope of contractual activity of the influence of discriminatory factors from the pre-negotiation stage through the determination of the terms of the agreement to the implementation of the bargain. The acquis communautaire has played the key role in elevating non-discrimination to the status of a principle of contract law, which has then been propagated through the individual national legal system by the harmonization mechanism. In the original version of the European treaties, the prohibition of discrimination wasn't a central element, and above all, it was focused on the objective of ensuring the free movement of the factors of production and the establishment of the common market. Then there was a change in the European law approach, which is enshrined in the Treaty of Amsterdam and above all in the Articles 20 and 21 of the Nice Charter. Why? It was an expression of a general reconsideration of the role of the prohibition of discrimination under European law, and involved both an expansion of the types of prohibited discrimination as well as the reinforcement of the horizontal effect of the prohibition. Nowadays, the prohibition of discrimination is direct actionable in relationships between private individuals. So within the new European law, the prohibition of discrimination has been extended beyond employment relations to all market exchanges and applies in relation to gender with the directive number 113 of 13 December 2004. Although the view that parties have full and absolute freedom to choose counterparties is still very widespread today in European contract law, in fact, the choice of contracting party is now governed by copious legislation, which subjects to review any inequality effects within access to goods and services. And I think that eloquent proof of this new legislative approach is offered by the initiatives that have been undertaken to review the European law of contract. For example, the acquis principle and the draft common frame of reference. Why the anti-discrimination directives may not have been conceived of as directives in the area of contract law, the acquis group, developing the perspective opened up by the case law of the Court of Justice that regards non-discrimination as a general principle of the community law, the acquis group has included the prohibition of discrimination amongst the general principles of contract law, and the draft common frame of reference dedicated chapter 2 of book 2 to the prohibition of discrimination, and for the first time discusses the right not to be discriminated against. And I think that the adoption of this terminology is very important because conceptualizes non-discrimination not only in the objective terms of a prohibition, but also with reference to subjective legal interest. So nowadays, the principle of non-discrimination penetrates into the heart of private law, the law of contract. It's possible to identify a common conceptual core of the prohibition of discrimination in relation to contracts. First, discrimination doesn't mean individual aversion. Anti-discrimination rules prohibit any significance being afforded within the contracting process to particular personal characteristics, the risk factors. These are elements of an individual's identity, which have been enumerated in law due to the widespread prejudice in relation to them. And these differences include gender and sexual orientation. The diffusion of the prejudice justifies the prohibition because these prejudices potentially entail exclusion from access to contractual exchanges, so produce social marginalization. Is disputed the application of the prohibition on indirect discrimination within contract law. What is indirect discrimination? It may be regarded as a technique that seeks to give significance to the otherwise invisible causal link between a discriminatory factor and inequality. So the analysis is focused on the likelihood that the exclusion is not causal, unmasking the supposed neutrality of a criterion for access to contractual benefit, a criterion which is apparently applicable to any individual, but de facto acts against members of one particular group compared to society as a whole. And in this way, the core of the problem consists in the need to justify less favorable contractual treatment. For example, a prohibition on entry into a shop open to the public by clients wearing particular clothing, such as veil, may be considered to constitute indirect discrimination, where it's liable to result in a difference in treatment for the members of a certain group, for example, Muslim women. However, there will be no such discrimination where an adequate and proportionate justification can be adduced for the inequality effect, consisting, for example, in particular security requirements or the need to readily identify people. And in this way, the prohibition on contractual discrimination makes clear the twofold role which the principle of equality is able to play, both an individual right of the person as well as an objective limit on contractual autonomy. Within this perspective, it's possible to engage with the last issue, the issue of the nature, the structure of discrimination cases. According to the most broadly accepted viewpoint, discrimination cases are relational in nature because they require a comparator and two terms for comparison. So discrimination cases would be tripartite in nature, based on actual or virtual comparators. The comparison between two scenarios with reference to a pre-existing paradigm will in fact tend to consider whether a rule of equality has been respected. But the tertium comparationis reveals the inequality outcome, although doesn't indicate whether the inequality outcome is justified. I think it's possible to frame the assessment in different terms. And in fact, under current European law, not only discrimination doesn't presuppose the necessary operation of any distinction or preference, but rather simply requires an exclusion or restriction. And within the case law of the Court of Justice, if there are grounds for justification, there can be no discrimination. The European Court of Human Rights and the Court of Justice of the European Union had abandoned the comparative assessment model in discrimination disputes. Now they tend not to refer to a comparator, but to base the judgment on the link between less favorable treatment and the presence of a risk factor. In conclusion, the prohibition of discrimination should not prejudice the individual freedom to choose a contractual partner and doesn't give rise to any general obligation to provide reasons for contractual choices. On the contrary, the question must be resolved in terms of the justification of the inequality effect brought about by the exercise of private autonomy. Therefore, the direct applicability of the principle of equality within private law relations is inseparable from the issue of the review of contractual autonomy, where it expresses the core essence of the anti-discrimination paradigm. Thank you.
Thank you, Professor Carapezza Figlia. It was. Thank you, Professor Figlia, for this really interesting presentation. And now we are still in the field of contract law, and I would like to ask my colleagues from University of Belgrade, Snežana Dabić and Katarina Dolović, to deliver their presentation of their paper that is in the monography of
COVID
it's
contract relation and
COVID.
gender perspective.
It's about really intriguing aspects of impact of COVID on contract relationships.
Mm-hmm.
Thank you for this introduction, and thank you, Marita, for organizing this event. I will be the one who will start our presentation. My name is Snežana Dabić, and me and my colleague will be speaking about the relations between COVID-19 and contracts. Especially whether the COVID-19 pandemic has had an impact on contract relations, but we also connected this topic with gender equality. So we will look at it from a gender perspective. The main questions actually we pose in our presentation is who has been more affected when it comes to contract relations, whether that were women or men, and what are actually legal consequences, that is, which legal means can be used when contractual parties could not perform their obligations in a prescribed manner, either because it was impossible for them to perform them, or whether it was just it has become just too difficult for them to perform it. So, in the first part of our presentation, I will shortly state some of the facts which show that women have been more affected by COVID-19 pandemic when it comes to contract relations. And then in the second part of our presentation, we will just speak about the legal means generally when some contract has been, let's say, affected by COVID-19 pandemic. So I will start with the general equality part. We have doing some research about gender equality and COVID-19, and these are some of the facts we have found. Firstly, unlike in some other recessions in the past, COVID-19 pandemic has, I will say unfortunately, affected women more than men in terms of losing jobs. So women were now, as of 2020, as of the outbreak of COVID-19, in a position to lose jobs more often than men. So the first question is, why is that so? There are a couple of explanations. First of all, this need for social distancing has, let's say, led to such consequences that many jobs that maybe could have been spared in previous recessions are now being lost because of the COVID-19 pandemic. And this is especially true for some sectors like tourism, arts and entertainment, education, accommodation, hospitality services, etc. And these are all female-dominated occupations. That is, women work more in such sectors than in some others who were, let's say, more spared during the COVID-19 pandemic. We have witnessed that many states have imposed measures such as closing of shopping malls, hair and beauty salons, schools, etc. Also limited the number of people who can be indoors, etc. So, given the fact that these are mostly sectors which are employed by women, this is one of the facts why they were more affected than men. Secondly, these are also sectors in which it is pretty hard to work from home. So this telecommuting is not, it's either not possible or not so often in such sectors, because a hairdresser cannot work from home. It's just impossible. This is another fact. And thirdly, these are also sectors in which women have their small businesses, so they are not only affected as employees, but also as the owners of these small businesses. So if we have this in mind, this also affects contract relations because they lost their jobs, so these contracts are ceased to exist. Secondly, COVID-19 pandemic has also led to the increased need for childcare. We have also witnessed that many kindergartens, schools, faculties were closed. And according to UNESCO, I believe, more than 1.5 billion of kids and kids and students overall were out of school, primary, secondary, tertiary, kindergartens, etc., due to pandemic and the closure. And of course, the question appeared who is going to take care of these students and kids, since the schools and kindergartens are out of work. And when it comes to this increased child care, especially vulnerable part of the population were single parents, and we also know that women are more often than men in this role of a single parent, especially if they are vulnerable if they work and they are not stay-at-home single parent. And not only that, even if men were in and are in a position of a single parent, they usually do not live alone. They usually live with other members or other of the family or other adults. So men as single parents have more, let's say, support than women. Women usually live alone and do not have this kind of support. And when it comes to parents who raise their kids alone, statistics show that even though pandemic has, let's say, increased the number of hours men spend at home with their kids and doing household activities, it has increased for women even more. So women definitely are in a, let's say, worse position when it comes to this increased need for child care. And thirdly, when it comes to health centers and healthcare workers overall, women are mostly employed in such sectors, and I'm not speaking only about the doctors, but also nurses, non-medical employees, etc. So they, let's say, were more prone to getting infected or to suffer psychological and other consequences of the COVID-19 pandemic. So, to sum up, these are all some facts that show that women were quite affected by the COVID-19 pandemic, but also when it comes to their contract relations, not only in such a manner that they lost jobs due to the job closures, but also that they were more often in a position to quit their jobs in order to take care of their children, because we know that due to this social distancing, grandmothers and grandfathers did not want to take care of the children, or were not in, let's say, a position to do so, given the fact that they are the most vulnerable population when it comes to this development of difficult symptoms of infection or even the death. Also, the social distancing has led to another fact that other people were taking care of other children a lot less than it was before, and the price of babysitting has gone up, dramatically up. So all this has led to the fact that many women have decided to just quit their jobs in order to stay at home and watch after their kids. I'm now turning to the second part of our presentation, which concerns the legal effects of COVID-19 on contracts, and what are actually the legal means which can serve to contractual parties when they are in a position of non-executing their contract, that is, when they cannot perform their obligations, or they are just it has become too difficult for them to perform it. One of the legal means is the Impossibility Doctrine. The Impossibility Doctrine can be applied in those circumstances, in those contracts where one or more contractual obligations cannot be performed due to some circumstance that has appeared after the conclusion of the contract. But what will be the exact consequences depends on many different factors. I will only mention several factors. First of all, who bears the responsibility for this impossibility to perform. When it comes to COVID-19 and all the measures which have been imposed by the states, we can say that generally in many contracts it can be said that none of the contracting parties is responsible for this non-performance, because none of the parties could have avoided or foreseen that such a pandemic could appear and such consequences could have an impact on their contract. But we can also, and it will be an interesting task for the courts, we can also discuss whether in some cases there could be some responsibility of the creditor or the debtor, especially if the debtor has not, let's say, adhered to the prescribed measure. He did not wear a mask, or he didn't get a vaccine, or he didn't get a specific vaccine, and it has prevented him from performing his contractual obligations. So the consequences here can be quite different. Secondly, this impossibility to perform has to be, as I already mentioned, subsequent, and this means that a consequence that has a circumstance, that has prevented the debtor from performing has to have appeared after the conclusion of the contract. Since we are speaking here about the COVID-19 and the measures, it means that the Impossibility Doctrine will probably be applicable in the cases where the contract has been concluded before the COVID-19 pandemic, but it can also be applied if the contract has been concluded during the pandemic, especially if this, let's say, unforeseen circumstance considers, for example, a state-imposed measures, because in some cases, probably no one could have foreseen that the state would, let's say, close all the shopping malls or close the borders, etc. Thirdly, the consequences may also depend on the fact whether the impossibility was of a partial character, or the contract could not be, the obligation could not be completed at all, a whole obligation. Fourthly, whether it was an absolute impossibility, which means that the debtor could not have performed his obligation even if he would make every possible effort to do so. And on the other side, we have, let's say, so-called practical impossibility, which is a case where a debtor could have performed it, but under completely difficult, much more difficult circumstances. Fifth, whether this impossibility was of a temporary or of a permanent character. And sixth and final, whether the impossibility was objective or subjective. So I will now finish my part of the presentation, and my colleague Katarina will continue. Thank you.
Thank you, Snežana. I will continue now. The impact of the pandemic on the effects of contract does not come down only the impossibility to perform. It's even more likely that COVID-19 would only make it more difficult for the debtor to fulfill its contractual obligation, or would call into question the achievement of the purpose of the contract. The institute of termination or revision of the contract due to changed circumstances is well known in comparative law and represents deviation of the main rule, which means that contracts must be executed exactly as concluded. It's the rule of pacta sunt servanda. If we analyze, for example, French, Italian, German, and our Serbian law, significant similarities must be noticed in the formulation of the institute of termination of contract due to changed circumstances. Now we will just briefly present the conditions usually prescribed in the mentioned legal systems as qualities which a specific circumstance must have in order to be considered a changed circumstance. But of course also in the context of COVID-19 because of our topic. In other words, the question arises whether the COVID-19 and state-adopted measures, which is in connection with pandemic, fulfill all necessary conditions in order to be considered change. In our opinion, it could be concluded, but just in principle, that the COVID-19 has the virtue of change circumstance, and that it is possible to apply the institute of termination or revision of contract due to change circumstances. We say in principle because, in our opinion, the court should, in each case, determine whether the COVID pandemic or state-imposed measures had such an impact on the concluded contract that made it significantly difficult for the debtor to fulfill its obligations, or the purpose of the contract cannot be fulfilled anymore. First, in order to be changed, circumstance must be a new one, which means that must arise after the moment of contract conclusion. The focus of our interest is, of course, contracts concluded before the appearance of the COVID pandemic or before the measures adopted in connection with the pandemic. So, a new circumstance would not always be a pandemic. Sometimes it would be another circumstance, but closely related to the pandemic. For example, closed shopping malls, for example, cancellation of gatherings, theater performances, cinema broadcasts, isolation measures, quarantine measures, etc. Second, the new circumstance must be such that it makes it more difficult for the debtor to fulfill its obligation. At this point, it is interesting to mention frustration doctrine. Frustration doctrine in common law system, which allows for the contract termination only in the situation where the contract goals for both contracting parties is in question. For example, if we have a lease contract, if a lease contract is concluded for the premises in a shopping mall, and the state adopts a measure banning the work of shopping malls, the question arises whether the lessee can achieve the purpose of the contract because he's unable to work, he's unable to make a profit, and at the end unable to execute its contract obligations, payment of rent. In such cases, our courts, domestic courts, have already ruled in favor of application of the institute of termination or revision of the contract due to change circumstances. Similar example, for example, could be in the case of renting a hotel room for a pre-planned vacation that now cannot be taken because of the infection. Third, the new circumstance should be unpredictable or at least such that the contracting party was not obliged to take it into account in the moment of concluding the contract. The formulation differ from one legal system to another, but in our opinion, COVID-19 is a good example because the example of the COVID-19 pandemic has shown that the formulation to be taken into account is much more suitable than the request that the circumstance should be unpredictable. Why? Because this is due to the fact that nowadays almost everything is predictable, and it can be said that as pandemics have happened in the past, it could have been predicted that it will occur again in the future. However, when we ask ourselves whether at the time of contract concluding someone was obliged to take into account possibility of such a pandemic that would paralyze a world for a period more than 2 years, the answer is undisputable negative. At the end, it is undisputable that a pandemic is a circumstance that could not have been avoided or overcome. It could be concluded that the outbreak of the COVID-19 pandemic undisputable affected contract relationships, regardless of the fact whether women or men were in the role of the contracting parties. In some cases, the impact of the pandemic and, of course, state-imposed measures, which is in connection with the pandemic, has been such that it made the fulfillment and execution of contract obligations impossible. On the other side, fulfillment is possible, but it's now more difficult to execute the contract. However, as we have already said, the presence of certain circumstances indicates that contracts are more affected by the pandemic when it comes to women as contracting party. This can be, for example, a situation in which women get fired or maybe quit their jobs on their own because of the new situation. The new situation can be taking care of children due to closed kindergartens, schools transition to online classes, caring for infected household members, etc. And because of that, they are not able to properly execute their employment contract obligations. On the other hand, we have also mentioned situations in which women perform activities which are particularly affected by the pandemic or by the measures adopted by the state to suppress the pandemic and its consequences. Thus, for example, in the case of closing and restricting the work of hairdressing boutiques, salons, beauty salons, the question here which arises is how women as contracting party from the lease agreement, for example, will fulfill the contract obligations. So the main conclusion could be that contracts are more affected by COVID pandemic when it comes to women as contracting party and because of the all above mentioned circumstances. Thank you.
Thank you to Snežana and Katarina. And now I have a pleasure to announce a dear colleague of mine, Ljubinka Kovačević, a professor of labor law here at School of Law in Belgrade. And she's going to talk about gender equality in the world of work. So we are moving now to the field of labor law.
Yes, thank you very much, dear Professor, dear colleagues. I'm truly honored to take part into this conference. And of course, I will start with the fact that actually parties to employment relationship are not equal, since employee has to perform working tasks under managerial or normative or disciplinary prerogatives of employer. At the same time, those wages or salaries deriving from employment relationship are actually for majority of employees predominant or exclusive source of living. That's why one of the basic aims of labor law is to prevent abuse of employers' prerogatives and at the same time to ensure decent working conditions. And one of the most important instruments for achieving those goals is the implementation of the principle of equality, which includes the principle of gender equality. However, if you look at the first phases of development of labor law, in that period, actually, that gender division of labor that existed in family and society was reflected in the world of work and facilitated, actually, in some way, a secondary role of women in the labor market. So, traditional classical labor law is conceived under or according to the model of male worker who is engaged on the basis of open-ended full-time employment contract. For women, marriage or motherhood were some kind of substitutes for paid work for employer, and of course in some legal systems there was even a ban on employing married women, and that has as a consequence the fact that actually specific needs that women have as participants in the labor market were not sufficiently taken into consideration, and just the issues of protection of maternity or protection of women regarding their weak or weaker physical constitution were taken into account. Even after Second World War and that period of post-war welfare reforms that actually improved the position of women at the labor market, actually labor law continued to regulate just a few marginalized so-called women's labor law issues, and they were mostly oriented towards special protection of women because of their weaker constitution, like was the case with general ban on night work of women in industry, or, for example, a ban on employing women in physically demanding jobs. And eventually, that special protection often led to so-called banning discrimination or legal blockade of access of women to many jobs. The use of feminist method in many social sciences, including law, actually opened up a set of new labor law issues that are related to gender, and step by step that legal as well as institutional framework improved, having the principle of gender equality as one of the basic principles of labor law. However, many problems in this field, in the world of work, are still unresolved because women openly have difficulties regarding finding the job or to maintain the job or to advance in a career. And this can be explained by many reasons, including negative stereotypes and prejudice that employers do have regarding employing women and their work. Most of them are connected with that so-called double engagement of women, having in mind unpaid caregiving and paid work for employer, but also there are some other reasons, for example, discrimination in education, which is reflected in the field of work, and that leads actually to so-called occupational segregation, but also there are other reasons for that, which are reflected in the fact that, for example, majority of women are facing difficulties regarding finding a job or maintaining a job. Many women are engaged on the basis of part-time employment contract. To be more precise, when it comes to European Union member states, 4 out of 5 workers performing part-time jobs are actually women, which means that they have also lower wages. Then many of them are employed for a short period, many of them perform undeclared work, and so on. All those problems needs to be reconsidered in the light of current development or current tendencies in development of labor law. Starting with this political and economic turn to neoliberalism, because that turn is actually connected with the idea that employment relationship, work organization, labor law needs to be more flexible in order to reduce direct and indirect costs that employers do have. And that flexibilization and the regulation of labor law actually is quite harmful regarding female workers. And in general, implementation of the concept of flexibility and later on flexicurity, which was developed in the frame of EU, did not lead to, I do apologize, to long-term successful effects. Quite contrary, it led to marginalization and poverty of many vulnerable categories of workers, including women. Also, we have those neoliberal cuts in welfare, which actually makes women more responsible for caregiving. And if we have in mind that the trend of worsening of working conditions, which usually includes actually long working hours, or the need of employee to perform 2 or even more jobs in order to obtain decent sources for living, this can be very demanding and harmful for women. Next tendency that I would like to briefly explain is actually connected with the economic crisis and financial crisis. Some of the consequences of that COVID-19 crisis was explained by my dear colleagues Snežana and Katarina, but I will just say briefly that economic crises are, of course, usually connected with unemployment, oftenly long-term unemployment, and also with the trend of worsening working conditions. In first phases of economic crisis, in general, those male-dominated sectors will be hit, but later we will also have negative consequences in sector in which women are actually majority of workers. That worsening of working conditions usually includes also lowering of wages of salaries, and paradoxically, that lowering of wages will actually reduce the gender pay gap. Of course, we don't need that kind of instrument for achieving gender equality, but that is also one trend that can be mentioned. Then we have also a tendency which is connected with technological development. Of course, the technological development will will influence in a way that many jobs will be created. However, many jobs will be lost. We will have many redundant workers. It is presumed, for example, that in the next few years, around 14% of employees will be redundant because of technological development. Many of them will be women. And unfortunately, many of those women will not be able to find new jobs that are going to be created because of technological development. Why? Because many of them do not have those specific skills and knowledge that is required for performing those jobs, because of breaks in a career due to family responsibilities, or due to the fact that they are mostly employed on the basis of part-time employment contract, or due to the fact that many of them are working in informal sector, will not be able actually to have access to trainings, and that's why they will not be able to find those new jobs. Then I will also mention the tendencies, just few of them, that are connected with the demographic changes. They're very important when it comes to labor law, since it is sensitive to demographic changes. Of course, firstly, I have to mention that increased life expectancy and population aging, which is a great success of our civilization, but at the same time, it is a quite challenge for older female workers, because older female workers are actually helping younger workers to reconcile their family and professional duties, because older female workers are taking care about their parents, about their grandchildren, and so on. And that's why most of them, if they are employed on the basis of part-time employment contract, and also that means that they will have lower wages and later on lower old age pensions. Then there is one more demographic tendency that we have to have in mind. It was discussed in our first round table, and those are intensive international migrations. Of course, there are different types of international migrations and different statuses of migrants. Some of them are extremely precarious, and they are really connected with many delicate legal and labor, especially labor law questions when it comes to female migrant workers, especially if we are talking about, of course, undeclared female migrant workers, but also female migrant workers of first generation, because most of them will perform so-called 3D jobs. Those are dirty, dangerous, demanding jobs, and then work without any contract and so on. And when it comes to second and next generations of female migrant workers, their position will be, in principle, much better, since they're mostly educated in the host country. Then I will mention just briefly, since we have those environmental issues on the agenda that are going to be examined by my dear colleague Mirjana Drenovak, but just to mention one more tendency, and those are climate changes, because they are also very important for the world of work. If we have in mind the fact that due to climate changes, many jobs will be lost, and that is especially true when it comes to food production sector, where female workers are dominant. And then we have the fact that actually many women, because of poverty, are often more dependent on natural resources than men. And then due to social and cultural norms that exist in some environments, actually they will have lower geographical and professional mobility in comparison to men, which means that in the event of natural disasters, they will have less chance to find a new job than men will. So those are just a few of those current tendencies in development of labor law that I would like to mention. And now there is a second important question, and that is what are the labor law instruments that could help regarding achieving gender equality in the world of work or in matters of occupation and employment. When it comes to labor legislation, its capacity is quite limited. But labor law has some other very important instruments, especially when it comes to social dialogue, especially collective bargaining and collective agreements, because they allow those gender-related issues to be regulated in a flexible way at the level of enterprises, at the level of branches, national level, and so on. However, we have to have in mind that women are underrepresented in trade unions. For example, in the European Union member states, 40% of unionized workers are women. However, less than 20% of them are actually members of decision-making bodies in those trade unions. For example, collective bargaining committees or other decision-making bodies. Of course, there is not a strict rule, that a larger participation of women in trade unions and decision-making bodies would lead to achieving gender equality through collective bargaining. So we have to take this argument cum grano salis. However, it is important to stimulate the participation of women in trade unions bodies, in employers associations, their decision-making bodies, three-party bodies, in order to, in some way, be closer to that ideal of gender equality. And that further means that it is not possible to solve the problems that do exist in the field of labor law when it comes to gender equality without participation of all stakeholders. If we take into account contemporary labor law, it is, when it comes to achieving gender equality, primarily oriented towards empowering of women. Of course, that is important if we have in mind difficulties that women are facing regarding finding a job, maintaining a job, advancing a career. However, it is not possible to achieve gender equality without taking into account specific needs that male workers do have regarding those gender-related issues. Just think about stereotypes that some male workers are facing when they want to enjoy parental leave or use some other benefit or right concerning reconciling private and professional duties. So it is important also to take those needs into account and also to take all those changes into account from the perspective of gender equality principle, because unfortunately many of those tendencies are still waiting to be taken into account by legislators or by decision makers and so on, or are treated as some normal part or natural part of social context in which law is created or implemented or interpreted. And I think that it is time to change that approach. So I will stop at this point. Thank you for your attention.
Thank you, Ljubinka. I think that we are within the envisaged time frame, so we have two more presentations. Yes, now it's my turn, so I'll talk about, just a second.
Public policies.
Public policy, yes.
On gender equality, and your topic is gender-sensitive public policies.
Exactly. So let me just open.
Public policies on gender equality. Yes, gender-sensitive public policies. Okay.
Okay, so this is presentation that's related to our contribution. A colleague of mine, Vanessa Herves Parejo from the University of Cadiz, and myself, we wrote a paper on public policy implementation that aims to reduce gender inequalities in Spain and in Serbia. So we named it Tale of Two Countries. So I'm going to talk about Serbian side of the story. And generally, before I start, you can either use the term public policies of gender equality, or I think it's even more appropriate to use the term gender mainstreaming, because basically I think that's, at least my view, it's almost pretty much the same, because gender mainstreaming, according to various definitions, this one is from Council of Europe, means the organization, improvement, development, evaluation of policy process in order to incorporate gender equality perspective. So basically, our topic was about gender mainstreaming, and I'm going to talk about gender mainstreaming in Serbia. So what gets measured gets done. And the most appropriate measure, at least from my perspective, is the Gender Equality Index. You were talking about the gender pay gap, but this is just one aspect. There are a number of other aspects. And this Gender Equality Index is trying to basically incorporate various additional aspects that are related to gender equality, and it covers a number of sectors. So, for example, work, what is the access to labor market with respect to gender? What is time-wise use, actually how this time is being used on household activities between genders, the status of gender, various genders in with respect to power, the health, longevity, and other various other measures, educational attainment that's measured by knowledge aspect or knowledge pillar of gender equality index. So basically, this dark histogram is Spain, and orange one is Serbia, and we see basically that we do lag behind Spain in almost each and every aspect. Nevertheless, this is not the worst outcome for Serbia, because with respect to the other EU members, we are still ahead of 9 EU member states. So gender equality in Serbia is not at the very bottom. So even if we tomorrow join EU, we are not going to be at the very bottom. We are going to be somewhere in the second portion of this group. So this average index is not that bad, but still it shows that we can basically improve in almost each and every aspect. So how we can do this? The question is how we can achieve this goal, and we need to implement various public policies that colleague of mine talked about during yesterday and today. And what we try to do is basically to think about this gender mainstreaming or gender-sensitive public policies from 4-pillar perspective. The first one is our institutions. Which institutions are authorized to think about this domain of public policies? The second is more formally, when you have a policy cycle, you need to introduce certain public policy documents. So what these public policy documents are all about. And then what about not policy level, but regulatory level? What kind of laws we have in various countries? So this is regulatory framework. And then we move to what we call gender equality tools. You can have a best public policy document. You can have excellent regulatory framework, but you need to implement it. So what tools are we using in order to implement this gender-sensitive public policies? And basically, on the other side of this circle, you'll find what are the key aspects in Serbia. So basically, we do have 2 bodies, and they have their advantages and disadvantages. One is Coordination Body for Gender Equality, and the other one is Ministry of Human and Minority Rights. And what's really remarkable is that throughout our research and comparing these two countries, Spain and Serbia, there are remarkable similarities. There are certain distinctive features of both countries with respect to these institutions. And as I mentioned, we have this rather strong, because of the position of the leader of this coordination group, which is a vice prime minister, and then there are several other aspects. Coordination body for gender equality, which is basically leading the process. This body is the one that's responsible for strategies, for guiding the whole process, and for distributing tasks, and basically to exert a direct, indirect influence on gender equality throughout the policy process. The other one is Ministry of Human and Minority Rights, and it has a specific sector. And what are the key problems here? The key problems are funding issues and also temporary nature of these bodies. The coordination body evolved from the other body. Ministry is now here. It may not be in the next government, and this is pretty much similar in Spain. For example, they have now a ministry which is pretty much the same as the one in Serbia with respect to jurisdiction. On the other side, this ministry was existing, not existing. It was re-established by current Spanish government. So the problem is that you don't have a proper institutional memory. And what is also important is that you don't have a regulatory watchdog who is going to try to enforce and make everything in place. Good thing in Serbia is that we do have something that we call Public Policy Secretariat, which is regulatory watchdog. Basically, it's an institution that is going to take care that each and every law, each and every strategy or other piece of public policy document is going to have a gender equality aspect. And from the practical side, I'm currently working on something that we call National Adaptation Climate Change Program. And it really has a huge gender equality component. So we did our homework. There are indicators that are trying to basically connect this, something that already Ljubinka was talking about, how this is going to affect occupational position of women and men, and whether this climate change is going to. So this is something that's already in place, and probably because of Public Policy Secretariat, which is serving as regulatory watchdog, and it's looking at various aspects of gender equality issues. So this is second pillar. It's a policy document that exists basically in each and every country. You'll find a pretty much similar document. There are some subtle differences what these documents are focused on. So this is not the first one that we have in Serbia. It's almost like a third or fourth one, depending how you're going to count. And these documents are all adopting medium to long-term goals. There is always a vision that try to convey Serbia's objective with respect to gender equal society. And what you can see that this is really gradual. So even if you look at this gender equality index from the very beginning, the result for European countries, for member states, are improving, but really slowly. So from 63, that goes to 68 in 10-year span. So it's not something that you can achieve immediately. It really takes some time. What we looked in our paper is also how the cultural aspects and perspective affects these changes. And then there we also found a number of similarities between Spain and Serbia. This new strategy that we have is now trying to basically fill the gaps. So this is this incremental approach. What's incremental about it? This is the strategy that first time tries to incorporate intersectionality, for example, in our policy. And it, for the first time, really aims to systematically include and assess vulnerabilities and what are vulnerable groups. What's also specific, it's the strategy that recognized what Snežana and Katarina were talking about, basically how you should react to certain events like COVID pandemic. So this strategy recognizes these emergencies that may occur and how this should be integrated into public policy and documents and the laws. Unfortunately, there was an exercise that was done recently that tried to evaluate our government response with respect to gender equality to this COVID-19 pandemic, and it was not great. So basically, they neglected quite a lot this gender equality impact of pandemic. The third pillar is legislative framework. So legislative framework is something which is not an easy issue to overview, because you do have a law on gender equality in Serbia, which was recently adopted, but you have a vast number of other laws like prohibition of discrimination, prevention of domestic violence that are related to gender equality aspects. And then you have other laws which are either sectoral or that are related to other relevant gender equality and empowerment aspects that you may have. And what's important and what makes this law, I think, a huge step ahead from the previous one is that really it operationalizes tools. So this is the first law that actually enumerates tools and that states what actually you should use in order to achieve. It's not just a huge announcement or just stating the vision. It really provides some ways how you are going to operationalize all these public policy documents. So this is the list of the tools, and I just marked in red three that I think that are really important. The one is gender responsible budgeting, which is in place in Serbia for quite some time. I'll just provide a couple of remarks with that respect. Then you have balanced gender representation, not only in public sector, but also they are now spreading this to private sector as well. And also something that's related to collecting and disseminating relevant data. Why I'm saying this? Because without adequate data measurement, you're not really going to be able to assess the advancement in this field. One aspect that's important is gender budgeting. This is something where Serbia is pretty much advanced. For example, it started all the way back in 2015 with the amendments to the law on budget. And right now there are like 50 organizations at the national level that are already implemented or that are gradually introducing gender responsive budgeting, which is a nice achievement so far. The second good achievement is related to quotas. I don't know to what extent you already discussed these issues, but this is something which also achieved a certain level of a success, and I'm quoting several domestic authors, some of them are already present, that reached pretty much the same conclusion. Actually, we started with inclusion of quotas all the way back in 2002, and this is just a comparison with respect to our National Assembly. We just had a huge minority of women in Parliament, only 12.5%, and now it's exactly 40% in 2020. And I don't need to talk about representation in our government, which is we do have both prime minister and majority of ministers in the government are coming from women's side. And finally, the last but not the least, and this is probably the most difficult part to introduce, is gender equality impact assessment. So it's a rather technical tool, and the issue is how you are going to make all these people, public servants, to think about gender equality aspects, how they're going to introduce this into public policy making, into making of regulation, and because in quite a number of times you are not going to see this as obvious. So you really have to think through to see what are the effects with respect to gender inequalities. And this is also something which is new but promising in Serbia. We did introduce gender equality impact test in our public policy development and also in development of our regulations. So basically, this regulatory watchdog is looking and basically can prevent you from going ahead to some extent if the law, regulation, or some public policy document is affecting gender inequality, but ministry or other body that's authorized to produce regulation or some other document is not taking this into account. So basically, you should then take this tests into account and do it yourself as a proposer as a proponent of particular regulation or law, and then this test is just now being discussed by the public. So there is a public policy discussion going on. So you can find, for example, this gender equality impact assessment test on public discussion web portal. And just to briefly summarize, you are conducting this really easy test based looking at the law or regulation, saying, okay, this is affecting or not affecting gender inequalities. And then once you determine this, you're going ahead and then you are doing three parts of this assessment. The first one is you're trying to provide private public policy dialogue that occurred and whether that occurred. Then the most difficult part, trying to estimate impacts. And the third one, to what extent, once you recognize the impacts, once you conducted dialogue, once you obtained feedback, how you aligned it with the law on gender equality and strategy that deals with gender equality. And finally, this is also promising, and Serbia is something if we can brag about, we do have a good databases. And with respect to gender, this should be even better in the near future. This is obligation introduced by law on gender equality in the Article 12. We have basically obligation for public authorities to ensure that statistics makes relevant gender distinctions. So this is something that should provide a lot of material for future research. We are not having that much research, especially from I'm an economist from economics point of view. We do still have quite a lot of things to catch up and to do. So that's something that I had to say about it. And one more slide. Where we stand, what's a good side of the story is that we do have this systematic approach. Again, it's too slow. It takes quite some time. Also, the problem is that a lot of this is implemented because of EU pressure. But public awareness is much better now, and people are accepting and think that gender equality is important policy to pursue, and it's on the agenda, and basically this is something that policymakers are also aware of. So this is something that should be producing positive results in near future. So thank you very much. So now the last speaker for this session is a colleague of mine, Mirjana Drenovak, and she's going to talk about the environmental crisis and how this affects gender equality. Mirjana, please.
Dealing with environmental law and climate change law and policy is quite complex, but dealing with environmental and climate crisis and gender issues is complex even more. So, Dragica, thank you for the invitation to research and to think about this topic, and for the opportunity to present very first conclusions on this issue. And let me start with the sustainable future, because the importance of gender equality for a sustainable future has been formally recognized in Sustainable Development Goal 5 of 2030, Agenda for Sustainable Development. And to achieve gender equality and empower all women and girls is not a standalone objective, but it is important also for the achievement of other global goals, including those related to environmental and climate change challenges. Today, it is well known that environmental and climate crisis has specific differentiated impacts on women and girls or on men and boys. And according to UN Women, climate-related extreme events can lead to increased violence against women and girls. And we know that biodiversity loss places profound pressure on women and girls as land managers and resource users. And also as food producers, women are frequently at greater risk to endocrine disrupting chemicals in pesticides or persistent organic pollutants. What this shows is that considerations of gender and environment are crucial to our ability to achieve a just and green transition as an essential part of sustainable development. Gender inequalities, such as weak right to own land or reduced access to energy, water, and sanitation facilities for women, have a negative impact on human health, the environment, and sustainable development. As a base of contemporary environmental and climate change law, Aarhus Convention from late 1998 provides a framework for three pillars: access to environmental information, public participation in environmental decision-making, and access to environmental justice. And I truly believe that mainstreaming gender into the environmental agenda should be based in environmental governance. That concept has been recently supported by UN Environmental Assembly. The resolution adopted in March 2019 recognized the importance of promoting gender equality and human rights and empowerment of women and girls in environmental governance. We may identify at least three most sensitive issues that might influence women's participation in environmental climate decision-making and access to environmental and climate justice. The first one would be a social recognition. If you are invisible in everyday's life, your needs will not be thought of, let alone addressed in a crisis situation. And for that reason, the policy framework should define models through which environmental decision-making would become inclusive, involving all voices, including equal voices from women. The second issue is the lack of enabling and gender-sensitive legal framework, which is a prerequisite for women to enjoy their right to a healthy environment. National legal and policy frameworks on climate change, environmental and disaster risks reduction often do not provide the basis for gender-responsive governance. And even in cases where laws and policies do incorporate gender equality, they often treat women as vulnerable groups rather than as agents of change, and that restricts their ability to fulfill their leadership potential. The third issue is the lack of understanding of women's access to environmental and climate justice. Existence of legal remedies and mechanisms alone cannot be, of course, made to measure women's access to justice when the circumstances of access remains to be affected by factors not only inside the legal system but outside it. There is a need to look beyond the legal measures and into the interplay of politics, economics, and culture in women's access to environmental and climate justice. So what should be done? It is just about to be presented in concluding remarks. What we know is that climate change is a threat multiplier, and it escalates social, political, and economic tensions in fragile and conflict-affected settings. We are actually in the middle of triple planetary crisis of climate, natural and biodiversity loss, and pollution and waste, which places also triple burden on women. What we may do is to follow lessons learned from COVID crisis. In March 2020, the head of EU member states and governments invited the Commission to use Green Deal and its investment plan as a base for a comprehensive EU recovery plan, integrating the green transition to push forward and to boost green recovery and just transition after COVID-19. It was also initiated by the member states, requiring a green reboot that
puts green growth as a base of the recovery from the coronavirus crisis. Climate change could be a missing puzzle to boost green transition and transformative changes to a legal framework that empower women, enable their engagement, and protect environmental rights. It could be done through development of an environmental justice strategy, unique public strategy, as a cornerstone that would set a more integrated approach to deliver environmental and climate justice on the ground, ensuring that gender equality and the realization of women's environmental rights are prioritized. Thank you.
Thank you. So this was the last speaker for this session. Sorry. This was the last speaker for this session. And now I can open discussion. So there are quite a lot of topics we discussed. So if there is someone who... I know that this is the last session. It's already past 5, so please, yeah. Dragice.
So thank you. So I'm tired, so
So I do not really want to be just polite, but sincerely speaking, so great, the great speakers, very well prepared, with fantastic focuses and points, and also the whole field, not only one field, but a relevant fields covered. So it means that the whole conference could have been devoted only to these topics and to these authors, and in the future, why not? It should be done. So for the first moment, I could have comments for all presentations, but I have to be short and to give a chance to the others, and I will start with Rosemary and Fuensanta. So family law and protection of children. As we know, and there were talks about and presentations also here and in these books about how family law has been advanced, especially in the 20th, 21st century, with human rights central position in international law and then in national, etc., etc. And how the protection of children against violence has also been advanced a lot with through law and not only law. But then we have this very crucial perspective which Rosemary put on agenda, that still even that already improved family law has been reproducing either directly or indirectly the binary patriarchal pattern, more or less, but in a significant amount anyway. So it means she is inviting in a very relevant way and with good suggestions how to go further on to improve family law. And this pointing, focusing on the best interest of children as the invitation how to advance further on family law and civil law from the point of kids is very important. But then, so that is one part of the story. Another one is the rise of populism, of extreme right wing, of the movements, the global movements, which pretend to be the protectors of the family, meaning the patriarchal, the family, and they, when I say the family, so they really promote the idea that the family is only the binary, heteronormative, patriarchal family. which also implies punishment of kids. We had huge discussions here a few years ago when the law against punishing children was introduced. Then those protectors of the family, they spoke about, oh, why to prevent me from slapping the kid, etc., etc. So my question is very serious. So they're strong, they're in a rising trend, they're very well organized as the global movement. It is called World Congress for Family. Then they announced extreme right-wing movements which have been networked and very well organized, and they try to imitate civil society, global social forums, and they travel from one. For example, they were in Italy a few years ago, or Hungary, etc., and they protect the family. So what to do, Rosemary? What to do for Fuensanta against that is so? And the consequence is the Trump affected events going on in the USA. So and the consequence is that we can expect the ban of abortion further on. Maybe one day in Serbia, the movement against abortion in Serbia, as well as we have it in Hungary, Poland. So you understand what I want to ask.
Microphone? Yeah. Will that reach? Thank you very much. Dragica, if I knew the answer to your question about what to do, I would be a very lucky person. I would be a very wealthy person. I would be selling the answer. So I don't have an answer to what to do, but I think that what we see and what it reminds us of is that the family is always going to be an absolutely key site for cultural and cultural reproduction and for political contestation. And so we can never assume that positive developments there is a sort of linear trajectory of improvement. And instead what we continue to see is a kind of cyclical patterns of advance and retreat, of changes that are progressive and then retrogressive steps from opponents of those progressive. And those contesting political forces are going to be with us for a long time into the future. And so I think we have to, my answer is that we have to organise ourselves to be prepared for the backlash against any advances that we make, so that if we do manage to achieve some progressive reforms, we don't then sit back and think, right, our job is done, or let's go and think about something else and not keep our eyes on that area, because it will always come back. So, it's not a particularly hopeful scenario that I'm pointing, but I think it's a realistic one. About being aware and being armed, being forewarned about what can happen.
Yes.
Can I just add something? So I fully agree with you. So politically speaking, that's necessary, because achieved rights always again have to be struggled for. But on the other side, I think what we have to do. So I said they pretend and intend to identify family with patriarchal family. And what we have to do, much more, not only in academic environment, but also in media, in the public space, to explain in a convincing, with good arguments, in a convincing way, that the family is not identical to the patriarchal family. On the contrary, the new forms, much more democratic, with much more alternatives, have been already there, and that also do mean family. I think that is most, because they ideologically they also act very, how to say, efficiently.
Yep, no, that's a good point.
Do you want to? I think, Rajitsa, that family is the most basic way that person has to organize in society. Is the more basic. It's a society. Now we think in a social group and we think in a state, but the first social group was the family. And this way of organization has been changing for over the century, or maybe has not changed for many centuries, has changed recently. So maybe we have to take into account that there are different types of family, because persons have different types of organization in this way. So in Spain, for example, with the recognition of the same-sex marriage and the possibility of the person of the same sex to adopt, or we have different kinds of family. And when I teach family law, I explain that to the student, that there are social changes, there are social demands, and they have been reflected in law. For instance, in Spain, this recognition in the law has allowed to be in practice more different kinds of family, and maybe is the reason that I have. Is the idea that I think that we have to take into account, that family is not a closed structure. It's a way to organize, and there are different ways of organization or live this idea. So there are not only a family that are a mother and a father, or always can be two mother or two father, or things like that, like new realities.
Any more comments?
I really appreciate all this conference, from the starting point until the last point. Every speech was so interesting, and after reading all this book, now I have a clear idea. For sure, it's necessary to focus on education, on legal education. It's a big commitment that we have. As a scholar, as a person that has regarded as a lawyer. But just I want to add something, because it's my pleasure to see Professor Gabriele Carapezza Figlia. We were working together in Palermo. And the relation about your representation about gender private law is really interesting. But just I want to ask you if you have an idea in order to improve the gender perspective in private law, because as you say, it's a really sensitive topic, and to find the balance is not so easy. And in my opinion, there is one point that is very difficult, but very important. The intersection of different factors, because sure, women, disability, racial, we heard yesterday how in USA it's difficult to manage and to work for until today for the improvement. So maybe you, Gabriele, have some idea just to share.
Yes, thank you very much for your very interesting and important question. I think that nowadays the really new and important perspective in private law is the focus on remedies. The focus on remedies because the risk is an effective prohibition of contractual discriminations. I think that the legislation governing the private law protection that we can invoke against contractual discrimination offers a broad and complex machinery of remedies, and the courts can play a very important role in the development of these remedies. Violations of the legal prohibition of contractual discrimination may be countered with different forms of protection, which, as you said before, in some cases be cumulative. For example, we cannot accept any reading of the prohibition of discrimination only as a requisite for validity or as a rule for establishing liability. Sometimes discrimination produce a transaction which is void. Or sometimes instead discrimination occurs only in the pre-contractual stage, for example, when it consists in a refusal to pursue negotiations. And so in this case, the core remedy is, by contrast, in the injunction. And so, for example, we can obtain the cessation of the detrimental discriminatory behavior or conduct or act. Sometimes we can issue an order of specific performance. And so we have the question of the possibility to obtain the contract. In addition to refusal to contract, discrimination may consist, for example, in the imposition of individual clauses that results in less favorable treatment. And so in such cases, which is the remedy? Probably the remedy is the correction or the integration of the contract, or, for example, when the discriminatory conduct results in detrimental consequences for the victim. So in this case, the remedy could be a special provision on damages. So in terms of remedy, I think that we have a great field of work, and we have to develop a new machinery of contractual remedy that we have to focus on the particular nature of the interest. I think that this is really a new, very interesting perspective, and doctrine and case law could work together. Thank you.
I agree with you. It's the point is remedies in order to make effective the gender equality law. It's a crucial point, and really we want to work with that.
Thank you. Thank you, Professor Carapezza. Anyone else wants to raise the issue? Sorry. Please.
Thank you for your presentations. I'm particularly interested in these issues within the family law. As I remember, yesterday you were talking, Rosemary, you were talking about critical feminism and these approaches. I think you also edited a book on this. I mean, I also wrote an article also for the next textbook on the creative legal theory. And there are lots of streams with the LGBTIQ activism who are actually criticizing this institution of marriage. Not only in sense, I mean, there are like this liberal streams who are actually advocating for applying this very heteronormative conception of marriage also to LGBT. And then you're actually reproducing the same norms. So, I mean, this also happens within the LGBT communities, or you have partners, one is performing more male roles, one is performing more female roles. This also happens to lesbian couples. So you're just reproducing something, and you try actually to assimilate something which could be quite critical. So, you're talking now more on this ideas of regulations, but what are your stance on this institution of marriage as such, also for the others as well? In sense, should we? Because I'm talking about this because there is still potential among the LGBT community to deconstruct, but the LGBT activism is going more into this sense, liberal stream sense, like recognition, and this potential of criticism, I think, is going to be lost to deconstruct marriage.
Yeah, no, that's a very good point, and I think it's a tension, isn't it, within and perhaps sort of different. So people who would call themselves LGBT activists or equality proponents and queer arguments, and therefore, a tension between recognition, incorporation into the existing norms versus busting the norms altogether. And so as a critical scholar, personally, I would always be in favour of busting the norms altogether. And it's similar with, the feminist critique of marriage has also been lost in some ways in the sort of same-sex marriage debates, in a way, because there's a long-standing feminist critique of the sort of patriarchal and heteronormative baggage of marriage, and that why on earth would anybody want to join that institution when we should be overturning that institution, and so I have a great deal of sympathy for that. And then the sort of converse argument that, well, if you let us in, we will change the institution. I don't see any evidence of that actually happening yet, because what I see is I suppose young LGBTQ people entering into relationships, having children, reproducing, sort of homonormative families, if you like, rather than sort of really providing alternative models of relationships. So yeah, I certainly take your point, and I think that there's a very strong argument, critical argument to be made about, whether the same-sex marriage movement is progressive or regressive. It's interesting, in the New Zealand Feminist Judgments book, there's a rewritten judgment. So there's a judgment in New Zealand, as there have been in many countries, about whether marriage should extend to same-sex couples and, the concept of marriage. And there was originally, there were going to be two different rewritings of that judgment. So one liberal rewriting, which said, yes, major social institution, gay men and lesbians should be admitted to that institution, and given the recognition that their relationships deserved. And an alternative, a queer judgment, which would have said, why on earth would anybody want to enter in the institution? What the law should be doing is withdrawing its approval altogether from marriage, and not shoring up a patriarchal institution. And the second judgment never got written, and it's funny because in the particular context of deciding a legal case, the person who had been going to write that judgment decided that they couldn't use the claimants before the court as an instrument for advancing their own, political critique. So the people had come before the court asking for recognition, and it was not the court's job to say you shouldn't be asking for that. So in the context of a judgment, they felt that wasn't appropriate. But in the context of activism or sort of broader policy development, I think absolutely that critique needs to be further advanced.
Dragica, please.
So first, just to say, Mirjana had to leave because two of her kids were waiting with father outside for more than half an hour. But what I wanted to ask her, never mind, I will ask her, is survival versus or combined with sustainable development. These two. So survival always, again, from the point of environmental crisis, has worse impact to women. But never mind. Now it's not important. What I want to ask Gabriele, Katarina, and Snežana, how to convince many private law professors at the first place, and maybe then other legal experts concerned with private law, lawyers and the others, that gender perspective is relevant as it is. Because I know many private law, many or a few, it's enough to know a few private law academic staff who have been a priori against and considering private law as a positive law, which has nothing to do with these ideological, problematic, controversial issues. That is the question for three of you. So what are the best arguments? It's not necessary that all three respond, but some of you. And then for Ljubinka, more the comment than the question, but it can be transformed into the question. So I like very much something what she mentioned at the end. I like the whole genesis and this, how to say, opening agenda for relevant issues related to different crises. I like it very much. But this one, when you mentioned male, female context, in the framework of labor law, and then we maybe even can expand in the context of the relations, the issue of balancing work and home obligations. So this, importance of male or male, female, not only female actors within this gender equality, labor law context and discourse. So you can clarify even more if you want, but or just comment to my comment.
Okay. So, I don't know whether Professor Carapezza or, sorry, I don't know whether Professor Carapezza or Snežana and Katarina wants to.
It's okay. Okay, we can.
In our opinion, there are no legal rules in Serbia which directly create gender inequality. And because
of the contract law,
in the field of contract law, and because of that, at first sight, it seems that there is no
the question of
gender inequality. Yeah. But it's not the.
It seems irrelevant at first sight, but when you go into the practice and when you see how contract law is practiced from a gender perspective, there is where we see this gender inequality. So maybe the best way to convince professors or legal practitioners is maybe to make them see these inequalities in practice and then connect them with contract law.
It's also in the field of property law. It can define some gender inequalities.
Yes.
Maybe more than contract property law.
There are actually some legal rules which also in the first sight seems to be going forward to gender equality, but actually when we see how they are actually applied in practice, they they take us all in the other opposite direction. So I think that seeing how legal rules are applied is the answer to your question.
Okay. Would you like to add something?
And
we have
one
question for Gabriele, if it is possible.
Okay. I don't know whether Gabriele can hear us. You can hear us?
Just one question. Yes.
Hello, I hope you hear us well. Here in Serbia, you mentioned the pre-contractual phase, and one question popped in my head. When it comes to negotiations, they are of course not an obligatory phase, and they of course do not have to lead to a contract conclusion. So my question is, what do you think, what could be possible consequences when one negotiating party wants to leave negotiations just because the other party is represented by a woman? Unfortunately, I have seen this in practice that especially when negotiating parties are coming from different cultures, they appreciate it more when they talk to a man during negotiations in comparison to situations where when they have to, let's say, talk to a woman. So what do you think, what could be legal consequences? Because in Serbia, as I mentioned, negotiation doesn't have to lead to contract conclusion, but on the other side, if one negotiator leaves negotiations for no reasonable cause, it can lead to damages.
Thank you very much for your questions. First of all, how to diffuse a gender perspective in private law. I think that probably the most important argument, the most important instrument is to identify the legal basis for the prohibition of discrimination according to a risk factor which is gender or sexual orientation, or in general to focus on the legal provisions and the principles of European law and of several international instruments, and above all the fundamental constitutional principles that represent a legal basis for a gender perspective in private law. Probably this is the most important argument. Gender perspective in private law is not nowadays a question of social values. We have several provisions, and I think that our task is study these provisions and contribute to the knowledge of these provisions that consider gender as a legal matter. I mean, probably all these provisions can be considered expression of the principle of equality, which now the case law, the European case law, but also the national case law, consider a fundamental human right immediately actionable against other private person. And I consider very important that in the last 2 decades, the Court of Justice of the European Union and also our Court of Cassation have recognized an absolute individual right not to be discriminated against, established in order to protect an area of freedom and potential of the individual against any type of violation. About the question of pre-contractual stage, what about when the discrimination occurs during the pre-contractual stage. So first of all, in this case, discrimination in reference to a risk factor, which is gender or sexual orientation, could consist in a refusal to launch or pursue negotiations. And so, which are the legal consequences, the remedies? First of all, we can have, and in the European context, we can have an injunction by which the legal system seeks to obtain the cessation of the discriminatory behavior, conduct, or act. It's possible also to issue an order of specific performance. In this case, the order of specific performance oblige the defendant to conclude the contract, provided that the goods or services are still available and it's possible to conclude the contract. Where the perpetrator persists in this unlawful conduct, and so he fails to comply with the obligation to act in a non-discriminatory manner, this circumstance may be assessed when liquidating the amount of damage payable. So in this case, the court shall take account of whether the discriminatory act or conduct amounts to retaliation for previous legal action or an unfair response to previous activity by the injured party. I think that these are the most important remedies when the discrimination occurs in the pre-contractual stage. In terms of remedies, which is the most problematic issue, the last topic, the possibility of real protection for the interest in accessing the benefits available through contracting. I mean, when the discrimination is a refusal to contract, the remedy of an injunction or an award of damage may not be adequate to in order to offer complete protection, because the injunction can be not complied with. So the question in this case is the court has the possibility to establish the effect of a contract that was not concluded. Probably this is the most problematic area of contractual remedies against discrimination. The possibility of a protection through specific performance.
Mm-hmm.
Thank you.
This is fine.
We have
Okay,
to
no more
finish.
comments?
No.
We have to finish because
Okay, so
Letizia has to close the conference.
if there is no...
Ljubinka,
Okay.
okay, sorry, sorry, Ljubinka.
Yes, I do apologize. Maybe just briefly to answer. Well, thank you, dear professor, for your comments. Well, my idea was that it is not possible to achieve gender equality without participation of all stakeholders, including male workers, other men, and all other participants in the labor market, but whole society. That was the idea. And when it comes to world of work, it is important because one of the main characteristics of modern world of work is actually a job quality erosion. That's why this issue is also important, not just for female workers, although they're facing many problems in the world of work, but also to male workers, not just those that have some specific needs in the world of work, but all male workers. So that was the idea, just briefly.
So I guess that we are approaching to the very end of our session. We need also to close the conference. So I guess that we can officially say that this session is over. And I don't know whether Dragica, you want to take your seat now, or you can do it from here. Okay.
I can do it
Okay.
from here.
Don't.
Do you want to come
No,
in?
better.
Yeah.
Yeah, of course.
And I want to ask about water.
Ah,
Because waters are good, but depending on which women who take part taking to quotas is
and
even more important.
and also it's quite different situation at the local level. So
Do you want to sit here? No, it's okay.
Okay, so we are coming to the end. I feel and believe that you're tired, but I'm sure because I have that feeling. I feel happy and satisfied because I really think that we got an opportunity to hear so many good presenters and to get new knowledge and new inspiration how to think about different topics of interest for gender equality perspective. So maybe I'm subjective, but I'm very satisfied. And so this conference couldn't be much more simply organized because we had to present the textbook, which is rich, very complex with many fields of consideration. We also wanted to include these not attractive but relevant, attractive to somehow, but very relevant issues like migrations and COVID, etc., and to reconsider our reconsiderations of different legal fields from this particular perspective as well. And we wanted to include as many as possible the LAWGEM project team participants, and you could witness how devoted and how well prepared they are from all our universities, starting from Örebro, starting from Cadiz, or Saarland, or Belgrade, or which is
Lumsa.
Lumsa, I'm tired, and Lumsa. And then, of course, we wanted to get very fresh insights from the best keynote speakers, which we considered as the best, and we how to say, proved that our impression. And I'm so grateful to Rosemary Hunter, to Marian Rubenkamp, to Adrian Wink. Ivana Jelic couldn't come; she feels better, fortunately. But these three keynote speakers, how to say, put the mark to all these our internal. They are not internal. They are relevant, and everything together comes as the complex, all-encompassing, well-integrated approach to gender issue from these different perspectives. So I want to express once again my gratitude and appreciation to you keynote speakers. Then my gratitude and appreciation to Damir and Cetina, who did a great job with presenting the book. And also my gratitude to all my dear friends. We have become also friends because we have been working since 3 years ago together, and hard. We are working hard, and we are working from, as I said, from different universities, but very well as the unique community. And I think that's something the best what somebody can wish if he coordinates the project. So we really have been a very good team, and you could also feel how the Belgrade team is good. So to involve so many great young and not so young
I'm the oldest. That's not the problem. But independently from the age, but age is also in academic framework is important because these young people will bear the future of gender competent and sensitive approach in legal studies. And we know how legal studies have been generally, by definition, rather conservative, more or less, but always very often more more state-oriented than human rights protection-oriented. So we are doing a very important job. I also want to express my gratitude to all people who joined us from Belgrade University, from other countries, from Slovenia, Italy. We had and other members. So dissemination was also important, meaning that people out of Serbia and out of the LAWGEM project team had to be involved. And our students and all other people from NGO sector who were here, and not all the time, some all the time, but people have so many obligations. For example, at our faculty, exams, and we have so many students. Exams have been going on from early morning up to late evening, but people come, and I think it's very important. And just to finish with what's further, at first place to mention that LUMZA has already accredited Master Law and Gender. Belgrade is on the halfway, not half, more than halfway, because we have a more complicated procedure. First stage is university level accreditation, and then national agency for accreditation, something like that for accreditation. That's the second and the final step, which we still have not accomplished, but we will. And the next very important thing from the point of the follow-up, because sustainability of these kind of things. So we have so many good projects, and then when they finish the project as such, it was fantastic, but nothing after that. So sustainability and the follow-up, in our case, is, I think, solved in a promising way, meaning that LUMZA, Belgrade, and Örebro University will for sure go into the future application for Erasmus Mundus joint master degree. That's fantastic grant, and it secures sustainability of the Master Law and Gender for sure for all these universities, and the colleagues from Cadiz and Saarland University and others. We have already talked to people who will take part in lectures. Then we will have money, but without that Erasmus Mundus grant, we can only secure online participation of the people because there is no money. Money is needed. But if we get it, and we have very good chances, and the Erasmus Mundus joint master degree presupposes that at least 3 universities with similar, and we have it already built, similar or the same curriculum apply together, and then share on the basis of agreement made easily among us, share responsibilities for different courses, etc., etc. So that is one thing, fantastic one, and the promising one for the follow-up. Another one is this series, which we already have been contracted with Springer. So all of you and much more people from the world will have that opportunity to go with to participate in the 5th book, in the 6th book. We will, Ivana Krstic and I will start with the next call for the book Gender and Judiciary. And that's all what I wanted to say. Thank you very much, really. Thank you, Gabriele, and thank you all who are here online. I have to apologize. too much concentration to this room, and I very often forgot our friends and colleagues from this virtual company and classroom. So thanks a lot. Thank to all of you. And with this, I can say that we will close the session, and I hope that our keynote speakers and all these people here and those who took part in different things which we have been working on and have already done through that work will join us again for everything what we will initiate, and also can initiate and invite us to follow you if you have good ideas, because good ideas and good people, they do everything. They can do whatever they want. Thanks a lot. And for tonight,
not that I want to take lots of time, but I also wanted to say thank you for the invitation, and thank you to the great team of Belgrade University, who all have participated, making this a really nice experience for all of us.
So now we can make some appointments concerning the restaurant, River. Gabriele, we are sorry that you're not with us. Now we start talking about the restaurant and music tonight and enjoying that. So the next time. Thanks a lot. He couldn't hear me.
No.
I think he can. So you can't hear.
Sì. Sì.
See you in Palermo in October.
Yes.
Greetings. Bye.
Thank you. See you in Palermo. Yes. Thank you. Bye. I forgot to mention.
Okay.
Rosemary. Yes.